Hello, everyone. I'm Sal Carrera, Development Director for Vegas PBS. I want to start by welcoming all of you to our complimentary virtual seminar on aging alone and guardianship. We're delighted to have you all join us to hear our panelists discuss an important topic that will help you plan for the future. Seminars like this could not be possible without the support of expertise of our Plan Giving Council members who lead these events. Vegas PBS is committed to engaging the community with experiences that educate and empower all individuals. Today's seminar will be presented by three trusted and well-respected members of the Vegas PBS Plan Giving Council, Shannon Evans, Jason Oceans, and Patrick Clifford. Before we begin, I want to take a moment to quickly share today's format. Today's seminar will be presented in 3 segments, with each presenter giving a short presentation on the topic of aging alone and guardianship. Towards the end of the program, we'll have a Q&A session to get your questions answered by our expert panelists. Let's get started so we have enough time for all of you to submit questions for our Q&A sessions at the end of the program. Introducing our first presenter, Shannon Evans. Shannon Evans is an attorney with Evans & Associates, a firm specializing in estate planning, probate, and guardianships. Shannon was admitted to the Nevada Bar in 1991 and obtained her Series 7 securities license around that time too. In 1988, she was appointed by Congress to attend the Retirement Savers Summit in Washington, D.C., and made contributions to some of the changes that are now reflected in retirement plan distributions and portability. Please welcome Shannon Evans, who will be presenting on the importance of income planning, role of successor and professional trustees, difference between family versus appointed care provider. Take it away, Shannon.
Thanks, Sal. Thank you. So it's kind of a scary topic, aging alone and guardianship. Well, you might age, you might not. Hopefully you become older, and hopefully you might be alone, you might not. You might have a partner, you might have a family member living with you. But the main point is, if you don't plan, something will happen that you haven't planned for. So it's very easy to make decisions, and we're all going to talk about that you can have some control in what your plan is for you and your family. Another thing to really think about is all of us have family members, including parents or grandparents, during this hard time with the COVID pandemic that needed some help. So it's good to have a plan for other people in your family as well and encourage them to have a plan. A lot of people don't want to talk about this. It's not the most fun topic, but you know, it's something that you need to do. And so one thing that we're going to talk about that's really easy, not expensive, anyone can do it, is power of attorneys are a way to plan who's going to be taking care of you. There's 2 kinds, financial power of attorney and medical power of attorney. And you appoint a first choice or a second choice who would handle medical issues and who would handle financial issues if you were incapacitated. So if you plan those things, you can also plan who will be your guardian if you were incapacitated for a long time. For example, in your will in Nevada, you can list who your guardians would be, first choice, second choice, if you needed help. So all those things are really important because then you get a pick. The next thing to really think about is update your plan every now and then, because the people you picked may not be the right ones anymore. So I think we've all seen that many times where you pick a certain person to be the main one to take care of you, and that person becomes older or incapacitated and you have to pick someone else. So I think we all know that that's really a big thing and not expensive, really easy to do. So that's one thing. Second thing is, if there's a guardianship, it means the person was probably incapacitated for a longer period of time. If you have financial and medical power of attorney already in place, and maybe a trust, we'll talk about that, you might not need to go to family court, and it may be a really inexpensive and quick process. Family court and guardianship becomes involved when there's a longer term care situation happening and there's not really something in place, a plan in place. So I'll give you an example because stories are always better. I had a couple that was older. They met during World War II. He was a soldier in Germany and his wife was a German citizen, and they got married, no kids, lived together a long time, forever. So he becomes slightly incapacitated, beginning stages of dementia. That happens. And she was his caretaker. She's his first choice on the power of attorneys and medical and financial, and he named his brother a second choice. Who you name as second choice, and we all know this is just as important as who you name as first choice, because you never know, right? So the wife became incapacitated and broke her leg, and she was in the hospital for a very short time. During that time, his second choice, the brother, decided to take over, and things were not titled correctly in a trust to avoid any kind of situation, and he went to guardianship court, and he became the guardian of his brother, And when she got out of the hospital, they had their things in the driveway being sold. And that was not their intention. So you have to pick really good backup people to back up financial emergencies and medical emergencies. And so check your plan. Check it for your parents. It shouldn't be a family decision about who's the best person. It's more who's the practical person who can take care of financial issues or medical issues, right? And I'm sure, Patrick, you've had that happen many times. Why don't you chip in a little bit about power of attorneys?
So powers of attorney are really a wonderful way to empower yourself to make decisions because, as they say, if you don't have a plan, don't worry, the government does. You probably won't like it as much. So if you can name someone who can take care of you, make decisions for you financially or medical decisions if necessary, or having a trust to deal with your property, that's so much better than needing a guardianship. And we'll talk about this in a little bit, where the court will appoint someone to do these things for you. So
Patrick, that was a really good point. We were going to talk about trustees. Okay, a trust is a great way to avoid any kind of problem because if things are titled in a trust, and you can change it over time, you can make sure that if you're hurt, the trust terms will be followed and you'll be taken care of. And when you pass away, your family will get things probably with some tax benefits and make things very easy. The point of a trust is you pick who would handle financial issues if you were incapacitated. So that's a big choice. Do you pick a family member? Hopefully you have a really good son or daughter or someone that's really trustworthy. Whoever you pick has control of the things if you become incapacitated. So a lot of people don't like to do this, but it's a good idea to pick a backup as a professional trustee. I like local trustees in your community that can talk with the people and deal with you instead of a national one, but professional trustees aren't as expensive as you think, and they only get paid if they're in position to handle the trust because you were incapacitated. So you don't have to worry about who you pick until such time as they really have to do something for you. Also, one thing that we do often, and I'm sure Jason's seen this, is you can have flexibility in your trust and in your plan as to who will be the trustee. Let's say you name a professional trustee and you become incapacitated and they're not doing a good job. You can have someone in your family that you trust be a trust protector, a person who can check, they'll be a watchdog for the trustee and say, you know what, they're not doing a good job. I'm gonna remove that one and pick another one. So there's a lot of reasons to have flexibility. Another thing I was talking about just the other day, I don't know if Jason and I talked about this or not. I have a client who is young in her 60s, my age, and she had some cancer diagnosis. She's probably going to be fine, but she doesn't know. So she was thinking about working another year for a big casino, and she has benefits, but now she's thinking about going to live with her daughter in California. And her daughter has a new grandson, a 2-year-old baby, and she has a casita. So this woman's thinking about maybe leaving her work a little bit early if she can keep the insurance and go and living with her daughter in California. All these things have to be flexible because no one knows what's going to happen to your health or your work. A lot of people lost their jobs and they had to change different plans. So I think flexibility is the key thing to be involved in what kind of finances you have in place to handle some kind of flexibility. She's going to sell her house, probably tax-free. We can talk about that. Jason knows all about that. And sell her house tax-free and put the money in an account and go live with her daughter in the casita. And she'll have a nice nest egg to take care of her during, her old age. Jason, we've talked about selling a house and keeping the money tax-free. That's a great tax benefit. You want to talk about that for a second?
Well, I think you highlighted something critical, which is the importance of flexibility and being able to just navigate, given that you don't know what life's going to throw at you.
Right. And so as long as you have some kind of plan and you review it once in a while, it's fine and you'll probably be okay. I think everyone has situations where someone in their family was able to help each other and then that person became incapacitated themselves. Another really, really important thing to consider is whether you have a long-term relationship that may not be a marital relationship. And in this day and age, when people are getting older, a lot of people cohabitate and live together, and you have to include that person in your plan. Otherwise, they have no legal rights. So if you've had the same companion for 10 years and you're incapacitated, you may want that person to be able to make medical decisions along with your daughter. They could be both appointed as co-people for medical power of attorney. It doesn't have to be all or nothing. So I think it's really important to update those things depending on your situation and who you live with. Likewise, if you break up with someone or you get divorced or things in your life really change, you have to update your plan. And we've seen that many times, haven't we, where people forget to update things after they've had a divorce or a spouse pass away. And it's really critical not to avoid the topic and just go with it and update everything at the time.
and particularly people overlook beneficiary designations like on an IRA or an insurance policy. And if your beneficiary named beneficiary is no longer there, what happens then? Does you end
Right.
up giving it to the estate and going through probate, which is what you've been trying to avoid? Or is your spouse still named, your ex-spouse still named as a beneficiary?
It
That's
happens.
not who you want your money to go to.
It happens. I have another situation, a story. I had a husband and wife that were died on the 9/11 crash that hit the Pentagon. And I never met them. They passed away instantly, of course. And he had a large IRA, a big one. And they named each other. He named his wife, of course. And then they forgot to name their two sons as contingent beneficiaries. And the two sons were adults. They were normal, respectable people. And because of that, millions of dollars in an IRA had to go through probate. There were tax benefits they lost, and it was really a poor planning opportunity. And I think it's really easy to just update things and make sure that all your things are titled correctly. A final thing as you're aging, and you should do this anyways, whether you're old or not, is you should look at the titles on all your accounts. Look at your bank statements. Your bank statements, should they be pay on death to someone? That avoids probate. We can talk about that. That's a simple way to avoid probate. They could be in a trust. If they're in a trust, the name of the trust better be on that bank statement with your name, trustee, after it. That way you know the title's right. Your house. If you've refinanced your house, make sure it's in your trust name again after the refi was done, and that is a homestead. Those are huge things. If you become ill and there's a homestead on your house, it protects your house up to $605,000 equity. It's a big deal in Nevada. So it's a really easy document, a really easy thing to do, but people lose them when they refinance a house, and then they think that everything's taken care of and it's not in the trust anymore. So those are easy things for people to do.
Something that I think comes up a lot too is that hesitancy to make changes because it costs some money, costs a little money to make changes, but it costs a whole lot more to not make the changes, right?
Right. That's a good point.
Yeah.
And if you're going to do it, make sure you're doing it right. I've seen too many instances where people try to do it themselves and don't know how much they don't know, and trying to save a few bucks end up costing themselves a lot more.
Don't do it on the internet.
Yes.
Oh my God. Thank you so much, Patrick, Jason, and Shannon for that information. As a reminder to everyone who's listening, you want to submit a question, right? So you want to submit it in the chat and it'll come to me. It's being fed over to me. We're going to get to as many questions as possible at the end of the program today. We'll have a nice chunk of time there to make sure that we're getting to all of the questions that we possibly can. So next up is Jason Oceans. Jason Oceans is a wealth management advisor and certified exit planner with Westpac Wealth Partners. He helps clients make informed financial decisions on wealth accumulation, distribution, and preservation. Jason obtained his MBA from the University of Michigan Business School in Ann Arbor, focusing on corporate strategy, organizational behavior, and marketing. He's widely published nationally and locally, authoring articles on estate planning, investments, insurance planning, and retirement planning as well. Please welcome Jason Oceans, who's going to present on threats to income that retirees face and a framework for income planning and addressing these threats. Jason?
Thank you, Sal. As Sal said, I'm going to present on the risks, the threats that we face during retirement. I'm going to provide greater context by demonstrating what that looks like given the longevity that we face, and then provide a very high-level framework for us to follow. So if you think about retirement, it's fundamentally different from distribution. I'm sorry, from accumulation. So when you're climbing a mountain versus when you're descending a mountain, you face different issues, but gravity impacts you very differently when you're going down. It's very similar in retirement. All of the rules change, and the different economic issues that you otherwise face impact you pretty significantly differently. So when we think about the most important issue, it's longevity. So what you're seeing is mortality, representing effectively how long you live. And that's the risk of outliving your money. And the longer you live, the more likely you are to encounter the subsequent issues that you would face that we'll go through in a moment. So what that means is that you put a lot more pressure on these, on what could be a lump sum of money. So the second one that I want to cover is illness or injury. When you're working, what that represents is potentially losing your income, which you can address through income protection, disability insurance. But when you're retired, it could be pretty surmountable. It could be insurmountable. The idea that you have healthcare costs that could be increasing. If you look at the statistics associated with long-term care, they're pretty daunting. Statistically, 70% of those over age 65 are likely to require some type of long-term care assistance. And again, the longer you live, the more likely this is to impact you. Next, we think about volatility. During your working years, you gain the benefit of volatility theoretically in terms of market volatility producing results. So the more risk you take, it should result in obtaining returns. But when you're retired and you have a lump sum of money and the market's down and you haven't developed a more dynamic strategy and you're in a position where you have to withdraw from this lump sum and the market's down, then you effectively lock in the losses. And the sequence matters. So if you have several negative years early on during retirement and you're making withdrawals, it can have a pretty significant impact on the overall amount of money that you have in your wealth. Next, we look at tax deficient vehicles. So while you're working, while you're saving money, you're effectively reducing your existing tax rate, but what you're doing is you're deferring to the time when you do access the money during retirement. And if taxes increase, if your tax rate is higher, then it might not be the best decision. And almost in every situation, it's going to be your highest tax rate because you're taxed at your income tax rate when you withdraw money. And then lastly, we have inflation. So inflation, in theory, during your working years, enables you to command greater amounts of money. Yet when you're in retirement and you're living off a fixed income, then inflation is going to reduce your ability to afford to go out to dinner, to fill your tank. And as we see, inflation right now is significant. We don't know what it'll be long term, but it's impacting pretty significantly those in retirement. So if we look at the next slide, I want to emphasize the importance of recognizing that retirement could last a really long time. So what this is showing is the mortality curve of a 70-year-old man who's healthy. And I want you to focus on that middle line in the center. That's the 50th percentile. And what that's saying is if you have 1,000 or a large number of 70-year-olds, this will be the average. But it's not a brick wall that you bump into. It's more so a wall that half of the people climb over. So for the 70-year-old, the average life expectancy is age 89, which typically when I'm discussing this with clients is significantly higher than they otherwise would have thought and what they otherwise would have been led to believe based on what they may have read. So what that does is put a lot of pressure on their assets because the assets have to perform for a much longer period of time. And then what I wanted to do was overlay on top of the individual a life expectancy table on the next slide, including a partner. So if we have this 70-year-old recognizing that many people might be single on this call and many people might meet somebody, might have a love connection. So if we add that second life, and here the assumption is the same 70-year-old who's healthy with a 69-year-old female who's also healthy, what that does is extend pretty significantly the life expectancy. So when we look at the joint life expectancy, it's actually 94 to 93. So another way of saying that is somebody in their late 60s, early 60s who's planning for their retirement has to make sure that their wealth provides at least 30 years of income, recognizing that they don't get to choose if they're 50th percentile. Half the people are going to last significantly longer. So then when we look at the next slide, what I want to do is share a high-level framework that enables somebody during retirement to address the various risks. And the way I think of these risks is the following. Once somebody is educated, once somebody is aware of the risks that they're going to encounter, then they can either choose to address these risks or they can choose to disregard them with it, which is actually a choice in and of itself. So when we look at this, it's a little counterintuitive. We start in that middle bucket, true liquidity. So that's a bucket of money that's there just if you need it. So the idea of the true liquidity part is that money in the market or in some other wealth vehicle or some other asset is not truly liquid, because if you access it and you spend it down and it's providing income, it's no longer there to provide income. So with the true liquidity, it frees a retiree up to make smarter, more thoughtful, more strategic decisions. So then we look at the second bucket, which is the guaranteed income sources, and that's comprised of everything from Social Security to pensions, which are less and less common these days, to the engineering of a pension using some type of annuity. So taking a portion of the wealth and creating an additional pension-like guaranteed stream of income. So what that does is enable somebody to know that no matter what, they always have income to address their basic needs. And then once we've positioned an estate where they have appropriate liquidity and they have guaranteed income to address their needs to pay their basic bills, it frees up the remainder for other purposes, to be in a growth vehicle, perhaps in the market or whatever the estate dictates, and that can subsidize income, that can counter inflation or counter tax increases. It can be there for the future. It can be there to provide some type of legacy benefit. And when you look at these three buckets as an overall balanced plan, they enable somebody to address the various risks much more effectively.
Jason, can I ask you a question?
Sure.
Is there a mechanism that is linked to inflation so that people who are retired can actually ensure that their money they have to live on will be tied to inflation, so they will have more? You know, we're worried about their money's not going to go as far, but is there some type of investment you can have in retirement that will allow greater flexibility in dealing with inflation?
Yeah, there are multiple ways to address that. Of course, it depends on the individual situation.
Sure.
There are certain investments tips that are inflation sensitive, and then other ways to do that would be, if you're looking at the guaranteed side, to ladder different annuities. Another way to do that on the investment side would be if we're assuming that somebody is globally diversified, that they are adhering to the basic tenets of no stock picking, no market timing, they're long-term investing, then what we know is that the market historically has outpaced inflation, which means that somebody there are certain vehicles, but then they can also be strategic about it.
Okay.
But great question.
Thank you. Thank you so much, Patrick, Jason. We're going to move on. A friendly reminder to those that are watching, please submit your questions in the chat feature. They're coming in steadily. We'll get to as many of those questions as possible during the end of this program in the Q&A session. Thank you to those of you that have been submitting those questions. But before we get to your questions, I'm pleased to introduce our final presenter today, Patrick Clifford. Patrick Clifford is an elder law attorney and founder of Clifford Senior Law, in Henderson. He was admitted to the California bar in 1998 and the Nevada bar in 2013. After working as a civil litigator for nearly 20 years in California, he moved to Nevada in 2017 to open his own firm. His elder law practice focuses on estate and incapacity planning, probate, trust administration, long-term care planning, and guardianship. Please welcome Patrick Clifford, who's going to be presenting on guardianship, law updates, and the state of guardianship in Nevada. Patrick?
Thank you, Sal. I really appreciate the opportunity to be here today to talk to everyone about guardianship because it is such an important topic and is also very misunderstood. There's a lot of misconceptions out there. So I'm hoping to explain away some of those misconceptions and educate people on how the process works. And guardianship at essence is a court proceeding where someone goes to the court and says, this person no longer has the capacity to take care of themselves or make their own decisions, and someone else should be put in charge to make those decisions for you. And then the judge will decide, does this person need a guardian and who that guardian should be? And it starts with the filing of a petition. Someone will say, like I said, here's a person who needs help and they need a guardian to take care of them. And that's what initiates the process. So, and there are different types of guardianship. There are, of course, guardianships of minors and guardianships of adults, and the law presumes that children lack the capacity to make their own decisions. So that's a slightly different area. I focus on adult guardianships. There's also guardianship of the person, and that means that the guardian will decide things like where the person will live or taking care of their medical needs, making those decisions. And there's guardianship of the estate, which is dealing with that person's property to best benefit them. Now, one of the things you need to know about guardianship is that, particularly here in Nevada, the courts are always looking for what they call less restrictive alternatives. They don't want to put people under guardianship. So that's why planning is so important. That's why you want to have your powers of attorney in place. You want to have a trust if you have a significant estate. And unfortunately, people have gotten the impression that guardianship is inherently evil, or that guardians are evil people who are just out to take advantage of others. And of course, there are certainly going to be bad actors, but that is not true generally. And so often, no one wants to be in guardianship. I certainly don't want to be in guardianship court if I can avoid it, but sometimes it is necessary. There are people who need that help. Now, I want to talk a little bit about this big gulf between the perception of guardianship and the reality, and particularly here in Nevada. A lot of people's perceptions are formed by what they've seen on TV or on the internet and watching shows like I Care a Lot, and I cannot stress this enough, which is a work of fiction. Or many of you may have seen The Guardians, which was a documentary that came out about some really bad things that did happen in Nevada. That documentary came out in 2018, and a lot of the reforms that I'm going to be talking about came into effect in 2017, and I don't think that the Guardians really addressed those adequately enough. So people are under the impression that what they've seen and how bad things were are the way things still are, and that's not the case. And just as a little background, many people are probably already familiar about what happened. There were certain guardians who were taking advantage of elderly people. They were getting guardianship over people who didn't need it, showing up on the door saying, I'm now your guardian, I have control over your life and your assets, and you no longer live here. And they were forced to move out of their homes. Sometimes the homes were sold, and these guardians were running up ridiculous fees for them that were paid out of the accounts of the people they were supposed to be taking care of. It was a horrible situation, and of course, people complained, mostly family members, and led to some very excellent investigative journalism, which in turn led to other investigations, including criminal investigations. And as an upshot, some guardians went to jail, attorneys were disbarred. There was a lot of shakedown in this. These people had accomplices within the system as well. Other people, other bad actors saw the writing on the wall and just got out of guardianship altogether. So that was one effect, but also because of the added attention, the Nevada Supreme Court set up a guardianship commission to study how guardianship worked here in Nevada and what changes could be made to make it better. And that was in 2015. In 2016, they had their final report. And importantly, they had a number of recommendations, most of which were adopted, But the Guardianship Commission became a permanent thing in 2017. So now there is a body that is overseeing guardianship. It's an ongoing process. The commission is made up of judges and attorneys and guardians and advocates for seniors. So all of the parties are represented. All of the interested parties have a seat at the table so we can work these things out. Now, the reforms that came about, some were in the law and some were in how the courts handle guardianships. Most of these happened in 2017, and I think one of the most important ones was we have now a protected person's bill of rights. So first I want to say that the nomenclature changed. We're used to talk about people being incompetent and becoming wards. Those terms are not used anymore. We now talk about people lacking capacity and becoming protected persons. And it doesn't reflect just a change in the wording, but it reflects a change in the approach of guardianship and how we're really focusing on those people who need guardianship and their needs. But we have now a protected person's bill of rights, and it is in the law saying that people who are under guardianship, even though they no longer have control, have certain rights, including the right to be treated with dignity and respect, which you would think you wouldn't have to put in the law, but the right to remain as independent as possible. And I think one of the most, there's 19 enumerated ones, I'm not going to go through all of them, of course, but one of the most important is the right to have an attorney in a guardianship proceeding. And you don't just have that right. If someone files a petition for guardianship over someone else, that person will be appointed an attorney by the court. And here in Clark County is probably from the Legal Aid Center in Southern Nevada. You have these very dedicated professionals who will be there to advocate for the person and their wishes if they can determine what those wishes are. I've done that work as well, and sometimes, you know, I've represented people under guardianship who were essentially comatose. They couldn't tell me what they wanted, so my job was to advocate for them to make sure that people were acting in their best interest, and most importantly, that their rights were being protected and enforced. So, and the attorney's job doesn't end when a guardian is appointed. That attorney continues to be the person's attorney all throughout the time they're under guardianship, which means that for many people, they have an attorney for life. So that is huge because it's one thing to say people have rights. It's another thing to have someone who is advocating for those rights. Other things that happened in 2017, there was changes in how guardianship is run. You have to not only go in with petition, you have to have documentation as to why this person needs guardianship. They've changed the form, they require more. And they've changed the notice requirements. The person you're getting guardianship over, and I can't believe this wasn't a requirement before, you have to serve them with the papers, and they get copies of all the documents. But also, you have to give notice to the family. People say the problem was family members weren't involved. Well, now you have to give notice to parents and grandparents and children and grandchildren and brothers and sisters. And all of these family members have an opportunity to come to court and tell the court what their concerns are. Another big deal is they came up with a guardianship nomination form. And Shannon was talking about how you can put your nomination for a guardian in a will, but this form, you can put it down, your first and second choice, and you can submit it to the Secretary of State. And this form goes to a secure server, and it's not accessible by anyone but the courts. So if someone were to petition for guardianship over me, well, the first thing the court would do is see if I have a guardianship nomination form, and they would say, okay, well, Patrick would want this person to be his guardian, if not this person, then that person. And the court has a list of priorities, who will be appointed guardian or who should be. Court does have the final say, but that will be the first choice. So that's a very, very important matter. There's also a guardianship compliance office that was set up in 2017, and that assists the courts in determining how the guardians can be held accountable. They have investigators, they have forensic accountants who can go in and look at the accountings that have to be done now by the guardian every year. If it's guardian of the estate, the guardian needs to say, this is how the money got spent. So these are important safeguards. And, you know, if you suspect that someone under guardianship is being taken advantage of, there's a number of things you could do. You can contact the Guardianship Compliance Office. They have a hotline. You can contact the court-appointed attorney who will go right to the judge and bring this up so it can be addressed. And of course, under guardianship or not, if you feel that someone is being exploited or abused, you can always go to Adult Protective Services and start an investigation there as well. So I bring this up because, like I said, there are these perceptions because bad things happened in the past. People think they're continuing to happen. And of course, we don't have a perfect system, but there are resources that are available. And like I said, it's not a perfect system, but we are in Nevada moving in the right direction with the focus on the protected person, making sure that they continue to be protected. And really, I would have to say the best way to avoid any problems with guardianship is to avoid guardianship altogether. And I'm going to again emphasize that you can do this by preparing a power of attorney, a financial power of attorney, a medical power of attorney, and have a trust if you have an estate that needs to be protected because, as I said, the courts are looking for less restrictive alternatives. If you have someone you have chosen to take care of you, the court doesn't need to appoint someone to take care of you instead. They are going to defer to your wishes. So.
Fantastic. Thank you, Patrick. Lots of information from all of our expert panelists. I want to give everybody a last reminder, last chance, submit your questions in the chat feature. You can still do that. They'll get to me like within seconds. Before we turn to the Q&A session, I wanted to also make you aware that the presenters today have offered complimentary consultations to those that are interested in scheduling an appointment. To schedule an appointment, please stick around as the presentation concludes. Each of you will be given access to a seminar survey, which includes an opportunity for you to schedule an appointment. So now we're going to move to our questions. Let's see. Questions. I'm going to prioritize them a little bit from those that were submitted at registration, and then I'll go to the ones that are live, okay? So one of the questions that we got in registration was, I live in Nevada, but my family is in California. Are there guardianship considerations?
Absolutely. And in fact, this is one of the changes came about fairly early on. In 2015, they changed the law because previously, if you were in Nevada, you had to have a Nevada guardian or there'd be a co-guardian. And the problem with that is that they were really deferring to the professionals, the guardians, the people who know, and it minimized the impact that the family could have, particularly if they were out of state. And that's changed. And I represent people who have gotten guardianship over their parents and they're not in the state. So they can do that. There's no longer a requirement in Nevada that there be a co-guardian who is in Nevada. There's a small step you have to take. You have to have a registered agent. So if someone wants to, sue the guardian, they can deliver it to them, but that is a minor issue. But no longer is not living in Nevada a barrier to becoming a guardian of someone in Nevada.
And I think this is dovetailing on a guardian question. Did you have something to add, Shannon?
No, that's correct.
Yeah. The question is, does becoming a parent's guardian in any way make the guardian responsible for any debt incurred by the parent?
I can handle that. Actually, no. If you're a guardian of a person's finances and their person, you are not responsible for their debts and their liabilities. For instance, if they had a judgment against them from a car accident, that's not your responsibility to pay. However, you are responsible for handling their finances and handling their finances in a credible way. You're not supposed to just avoid creditors if they racked up a credit card bill. You have to negotiate with the creditors and see what can be done. Occasionally, someone has to go bankrupt if there's a significant judgment and an older person got in a car accident. Those are decisions the guardian of the finances would make, but they're not responsible for their own money to do that.
And as part of that process, unfortunately, one of the problems with guardianship is with all this court oversight and supervision, it requires court approval. So when you're dealing with things like settling creditor claims or selling a house, it basically requires a process of petitioning the court and asking permission and getting permission of the court to do these things. And that's, it's there for the protection of the protected person, but it is not an efficient process. It's time consuming. And when you have attorneys involved, it gets expensive. And again, that's another good reason why you want to have a trusted power of attorney act instead.
Because just to remind everyone, you may not know this, power of attorney is basically free and you don't need the guardianship court involved at all. You pick the people who would handle financial emergencies and medical emergencies and there's no court involvement. So unless there's a problem, that's much the easiest way to do it.
Since you touched on power of attorney, I'm going to read this question that just came in online. And it's, does a power of attorney from another state work in Nevada? And part two to the question is, does a power of attorney expire?
I'll take the second part first. Generally speaking, no, a power of attorney does not expire. You can, in fact, write your power of attorney so that it does end on a certain date or will end when something happens. One of the big developments in the law over the past several decades is that it used to be your power of attorney became ineffective when you became incapacitated. And that's when you need it the most. So the law in Nevada, the default is no, the power of attorney will not expire.
One thing, Patrick, that people forget, and even professionals forget, is once a person passes away, power of attorney is over.
Right.
It's for when you're alive. And a lot of people think, oh, you can handle an estate because you have financial power of attorney. No, that's not the same thing. That's an executor or a successor trustee. So people get confused. Power of attorney is only while you're alive.
Right. And the first part of that question, generally speaking, if a power of attorney will be recognized in Nevada, particularly if you have an out-of-state power of attorney, but you have to be careful because the laws are different in different states. So, for example, Florida does not recognize what are called springing powers of attorney. So you cannot have a power of attorney that only takes effect when you do become incapacitated. That doesn't work in Florida. If you went to Florida with a Nevada power of attorney, they might not recognize that. Nevada's a little more forgiving. But again, if you came from Florida and you want to make sure that someone can act on your behalf, if you don't want someone to be able to act on your behalf right away and you want to wait for something to happen, then you probably want to get that taken care of.
Great. Go back to the registration questions. There was a question here by one of our participants. Does Medicare provide in-home health care for those who live long?
So yes, but one of the things about Medicare as a government program is Medicare will pay for things that are medically necessary. As one of my colleagues describes it, Medicare is fix you up medicine. So and we see this a lot when people are hospitalized and then they go to rehab and then they come home, rather than providing that care in a rehabilitation facility. Yes, that can be paid for at home, but it has to be medically necessary. If it is more caretaking, then Medicare will not pay for that. There are programs, Medicaid programs, Medicaid waiver programs that will pay for that, but they do tend to be financially qualified, so there are income and asset limits. So, but there are programs that are available.
Fantastic. Thank you, Patrick. There's a series of quick questions here that I'm thinking are quick because they're short, but maybe they're not. Is there a simple living trust amendment add-on form?
No.
No such thing.
Well, there is a simple one if you want to cause problems.
These are
But the truth
online ones
is, if you have a change to your trust, let's say you move from California to Nevada, you don't have to junk the whole thing. If the basic terms are the same, maybe it's an easy amendment. So don't be afraid to have someone look at it and tell you if it's an easy amendment or a complete overhaul. It doesn't always have to be. You know, it can be easy. Go ahead.
Yeah, and definitely engage a professional attorney to make that assessment for you. I think, Sal, your earlier point, it can be much more expensive on the tail end, not to address it.
Yeah, the forms they have, like in the mailbox stores, don't use those.
And I think this goes towards that question as well. They're asking what type of fees are charged by a professional trustee, like what kind of ranges have you seen?
The trustee or the attorneys?
Professional trustee, what type of fees are charged?
Well, the trustees don't charge anything until they act as the trustee. So if you picked a professional trust company to serve, it depends what their fees would be at the time they had to actually take over the trust. You're the trustee while you're able. So I think they charge roughly, and you could roughly 1.5% of what they're handling.
Mm-hmm.
They're not handling things like a house. They're not handling things like, so it depends what they're handling. They're not handling things that you've already gifted to your children. They're handling what is being in your life while they need to be the trustee for you. It's got to be reasonable.
And it can also depend on the type of trust that you have. If you have a trust that is really about growing your investments and making sure that your money, is there and multiplies for your benefit in the future, the benefit of your families. The financial is different. We have what are called special needs trusts that allow people with disabilities to remain eligible for certain government programs. And there are trust companies that really focus on that. And they tend to charge a little less, and it's more of a flat fee, often only $1,000 a year to take care of someone, manage their assets.
If I may make a suggestion, we've all seen this, you've seen this. I like there to be a trust company where the person can talk to someone and have a human being that handles their case and their trust. It's kind of difficult when it's one of those giant companies and you always have a new person and you have to dial 1 and then you have to dial 9. I like there to be an actual person that you're relating with as long as they're with the company. Do you agree, Jason?
Yeah, and I think to your earlier point, it's a function of what they're doing. So if it's much more on the administrative side, then there are some that are designed to just administer, and they charge typically a flat fee. That's certainly not onerous. Whereas some where they're doing the investments or they're coupling with another service provider internally that's managing the investments, they're more likely to charge a significantly higher amount.
And certainly
be a
shop
percentage.
around, because all these trust companies, they're all different. They all have different approaches, and you will find one that is the best fit for you. And if you're looking for someone where a trust company where you know you're going to have a go-to trustee, then if that's what you're looking for, you can find it.
One thing, just to add to that, because it comes up all the time and you've seen it many times, is you might have a professional financial advisor or person that you work with all the time. They cannot be the trustee. They're prohibited from being the trustee. So you may have someone you want to stick with for your finances. You've worked with them 20 years. So they cannot be the trustee, but you can have your trust, for example, say you prefer to work with that person as long as the trustee thinks they're doing a good job or there's some capacity. And I think sometimes people want to stay with the people that they're using for long term.
Yeah.
They don't want it all just to change because there's a new trustee. That's important.
Thank you, Shannon. I'm trying to make sure that I don't repeat questions because there's some similar. So I'm going to jump to a question here that talks about pour over options. Can someone explain pour over will options?
Can I handle that?
Please do.
A pour over will is absolutely critical. And I'll tell you a quick story. Whenever you have a trust, you have a will that cross-refers to the trust in case something was titled incorrectly and the person died. Then there might be a probate or some kind of administration and it goes to the trust. I had an example where two people were in a long-term relationship. They were not married and they had a condominium owned 50-50, not joint, part by him, part by her. And he had a trust and his trust said she got his part of the house. But guess what? The house was titled in his name, not his trust, and he died. So guess what? She didn't get his half of the house. It went to his kids, which are not hers. You have to have a will that goes with the trust to coordinate them. It's absolutely essential. And in my opinion, it's malpractice not to have it.
Yeah, and the idea of a pour over will, what that means is just that anything you have that's not already in the name of the trust gets poured into the trust. And it's better, of course, to make sure you have the titling in place beforehand, because you could end up in a situation where the idea of a trust is to avoid probate, but if there's too much out there that's not titled in the name of the trust, once the trust is basically a beneficiary of the will, you might still have to go through probate. So ideally you get this taken care of first, but that's a good fallback position.
I think you just answered the next question, but I'm going to ask it anyway. Does setting asset account beneficiaries bypass the pour over settings in the living trust directions?
They can.
Yeah.
You can set your investment accounts TOD, transfer on death. Bank accounts can be POD, pay on death. They all avoid probate. The problem is you have to be dead. And what if you're hurt and they need to get in there and help you? So a trust has more flexibility in case you're hurt. And also, and you can talk to this, they have more depth to it. Instead of just the person, it might also be their children. And if their children are under age 25, the trustee would pay for those grandchildren's school and things. So the trust has more flexibility, whereas POD or TOD is just, it goes to that person if they come in with a death certificate.
And that is one thing also, is that if you have a beneficiary designation, like on a bank account or insurance policy or your IRA, that will control. That will control, that money will not go to the trust. It will not go to your estate. It will go to whoever's named as the beneficiary, which, as we discussed, could be your ex-spouse, not necessarily the way you want it to go. So take a look and take care of that.
Fantastic. They're asking for your opinion here. I think they're considering aging alone at home with a visiting care or a nurse, or moving to an assisted living facility. In your opinion, what should this person consider?
Depends on your finances. Depends on what you can afford.
I think it's a financial decision.
Right, it's a financial, and also sometimes people want to live at home, but they're like stinky hoarding people, and it's just a mess, and they need more help than they know. I'm just saying, we've seen that.
Yeah, I actually think of long-term care insurance as
Yes.
not have to go someplace insurance, stay
Yeah.
at home insurance. So when done well, it gives you the person the flexibility, your point about flexibility earlier. So I think it fundamentally is a financial decision.
And I do think, I mean, of course, it's a personal decision, but in my experience, it's better to keep people at home as long as they can. It is cheaper that people feel at home when they're at home. It's often a difficult transition when you're going to an assisted living facility, for example.
One thing that just happened, let me take this really quick. On our medical power of attorney, it adds new things every now and then. And last year they added a whole section that says, I want to remain in my home as long as possible, and my power of attorney may use my finances to pay for someone to take care of me. That's brand new, and most people are checking that box because it at least expresses an interest to stay at home if safe.
Right. And it's important you read that carefully. Some people think once you check that box and it says, I want to live at home as long as possible, and I do not want to give my agent the authority to place me somewhere, that doesn't mean you're not going.
No.
That's an example of, okay, we might have a limited guardianship because the agent does not have the authority to put the person in the place where they're going to be provided the care that they need. So it
Yeah.
doesn't mean you're not going. It just means it's going to be more complicated.
And there's always the memory care facilities, and that's
Yes.
always an issue in this day and age. When that's appropriate, it needs to be a special facility that's set up to handle people that have memory care issues.
Yes.
It's
And
not-
that, of course, is very important that there's ultimate authority because these are locked facilities.
Yeah.
You can't just grab someone, your relative and say she needs to be here and
Right.
put her away, because if you do not have that granted authority, if you do not have consent, you could be facing other legal problems like, false imprisonment, kidnapping, for example. If your relative doesn't want to go and complains about being placed there inappropriately, yeah, make sure you have the authority you are exercising before you act.
Good advice.
Yeah.
um, questions are all over the place just due to the fact that it's open Q&A, but this question goes back to power of attorney. Should you have a different person for medical and financial power of attorney?
It depends who your people are.
Yeah.
If you have perfect children, name them. If you have a spouse, perfect. But everyone has different families. Everyone has different situations of who they trust. Sometimes people name a sister who's a nurse or a brother who's a physician as their medical power, and they might name someone who has more financial background to handle finances. We all have different skills.
And I think just a fundamental question that I think a lot of people want to ask is, how do I start? What's the first thing I need to do? Do I pick up the phone and call a certain place? Do I go visit a certain place, or both?
I would say don't look for forms on the internet, but look on the internet and look at what is available. There are a lot of attorneys out there who provide powers of attorney. Rob Bullock, who's a member of the Plan Giving Council, actually has copies of the form power of attorney, the statutory form power of attorney, on his website. You can look at that and see, is this enough to cover my needs? And it's very basic. It's not tailored to anything specific or a specific situation, but that's probably a good place to start. And look at that and say, are these statutory form powers of attorney that the state of Nevada has adopted, is that enough for me?
That's the bottom building block that everybody needs. Everybody. If you have a child and they turn 18, you should get them a power of attorney, because guess what? If they're in a car accident and they're 18 or up, you might not have authority without court supervision. So it's really important that everybody have power of attorneys.
And that client I was telling you about, who was comatose and I was representing him in guardianship, he was only 33 years old. You never thought this is someone who would need a power of attorney. And I've dealt with people under guardianship as young as 19, adult guardians.
Yeah.
In fact, help people get guardianship over them. But as long as, and frankly, it's a good way to put your relationship with your children on different footing. It's not just, I'm here to take care of you, but I want to be able to take care of you. I mean, for example, once your kid turns 18, if they're in a car wreck, I'm sorry, HIPAA, we can't talk to
Right.
you. You are not authorized. We're not authorized to talk to you. So it puts it on a different relationship. Maybe at that point you want to add your children as your agent under power of attorney, as get that conversation going so you'll continue to take care of each other.
Maybe not for finances.
Maybe not for finances.
Fantastic. This is an excellent question that just came in. Can I contest a guardianship if I feel I don't need one? Or can you
Absolutely.
fire your guardian through your attorney?
Okay, you can
hard.
absolutely contest a guardianship. And in fact, that is what the attorneys that they will fight. If you think I don't need a guardian, I don't want a guardian, they will fight. And it ultimately comes down to the court deciding. So if you can show that you have the capacity, you don't need a guardian, they will present that evidence in the court. And again, the nice thing about it being in the courts is that there are all the safeguards of a court. There are appeal options. There is going to be a presentation of evidence. There are standards of review. It's not just a rubber stamp petition here, someone is now your guardian.
But let me add a little caveat to that. You're going to be paying for your attorney, and you're going to be paying for the other attorney, and they're going to fight, and you're paying for both of them. And it's not a fast process, and nor is it cheap.
Yeah.
So be aware. You better know what you're doing.
And they have actually changed it. You have to, if you're if you're petitioning for guardianship over someone else, if you want that person to be paying your attorney's fees, you got to put that in the petition up front. But as far as firing a guardian, no, you cannot fire your guardian.
Yeah,
you can fire your agent under your power of attorney, but only the court can change a guardian or fire a guardian.
Very interesting. We have just a few minutes left, but I wanted to make sure there's a specific scenario here that someone just sent over. See if I can follow this. Can I contest a guardianship if that's the other one. If a parent becomes incapacitated and there is a power of attorney in place, how does that work with the parent being primary trustee?
There's always a successor trustee in the document. So probably the person whose financial power of attorney is also probably successor trustee. Often that's the same thing, and executor. So often there's a flow of who would handle financial issues: trustee, executor, and power of attorney.
Yeah. Okay. And what's interesting is another change in the law. It used to be if you had a power of attorney and you went under guardianship, that power of attorney was terminated, ceased to exist. And now it's changed so that it's only suspended. So if you're under guardianship, you need guardianship for only a short time, or not permanent. Unfortunately, so many of them are. But for example, someone who is comatose, let's just say they're comatose for 6 months, they come out of it, they regain capacity. That power of attorney becomes the power of attorney becomes active again, and you could get the guardianship terminated.
Fantastic. Well, I think that does it for question and answer period. Thank you, everybody, for all of your advice today. Thank you. We're running out of time today, but if you have more questions, I encourage you to schedule a consultation with one of our presenters. Again, a survey will immediately deploy following this event that will allow you to schedule that appointment. And I'd like to again thank all of today's presenters for sharing their knowledge and wisdom with us. Thank you so much. I want to also add, please save this date, June 16th, 2022, on your calendars for our next in-person, I repeat, in-person plan giving seminar on power of your money, the power of your money. That's going to be our next subject. Also, set a reminder to tune in to Money Masters, a Vegas PBS original on Friday, May 20th at 8:30 p.m. May 20th, 8:30 p.m. This new series is going to answer your most pressing questions about investments, taxes, wills, trusts, and more in an easy to understand format. The first episode will feature 3 money masters that will discuss building and growing wealth, accessing and enjoying wealth, and transferring wealth and leaving a legacy. Vegas PBS is pleased to bring you relevant programs that help put our members on the path to financial literacy. Until next time, take care and have a wonderful day.